After hearing the matter, the arbitrator will be required to give a award. How this so at the end the arbitrator, after considering, here again there is like conciliation, there is no requirement for taking consents or the consensus of the parties. The arbitrator, similar to a judge, will finally decide the matter. In case the arbitrator decides the matter in favor of the investor and directs the market participant to pay certain compensation to the investor, in such case the market participant has to make the payment within 15 calendar days of the date of the arbitration award has been made. Okay, maximum period is 15 days. In case the award says that there is a less period has to be provided, then the period mentioned in the award has to be abided. The MII who is monitoring this arbitration process also monitors whether the payment has been made by the market participant. So the entire overall, this is the outcome, and this may go over the investors. Now, in case the challenge is required to be made, where let's say a market participant against whom the award is made, he wish to challenge the award before a court. In such situation, that market participant will have to submit an intention that he wish to challenge the award within 7 calendar days, and this he has to submit it on the ODR portal. He has to give that information. So as soon as he places this intention or submits his intention on the ODR portal, the other party, that is the market party, that is the investor, and the MI will receive that information, and a notification will be going. Now, in course, when the matter is challenged, so he will file a proceeding before an application before the court, asking for a setting aside an arbitration award or something else, or seeking for a stay. In such case, the stay has to be obtained within 3 months from the date of receipt of the award. In case the stay is not granted by the court within this 3 months period, then the market participant will still have to complete the payment and adhere to the terms of the arbitration award. So here is the situation where also that in case the market participant wants to challenge the award, at the time of giving the intention, he also has to pay 100% of the amount mentioned in the arbitration as a deposit with the MII, even prior to filing the challenge or approaching the court. This is how the arbitration award is enforced and enforceable for the purpose of the completion of arbitration award, etc. So what happens when the matter is challenged? So when a matter is challenged before the arbitrator, the first he has to deposit the amount to the MII, and if case he does not deposit the amount, then there could be a consequences for the market participants, which are like he may be declared as a not a fit and proper person as per the SEBI regulation requirements, or its license may be liable to be cancelled, or there could be suspension of business activities. Okay, in case of listed companies, if they fail to deposit the amount, in such case they may also have penal consequences that can be determined by the exchanges. So it is very important for the market participant to either abide by the terms of the arbitration award, make the payment, or if he wants to pursue or challenge this award before a court of law, he takes steps immediately within these timelines to get the stay order or something. That is very important here. So after getting the award, the arbitration award, the amount has to be disbursed. So in case by any chance it may be possible that during the arbitration proceedings which are ongoing, or where the matter is challenged by the market participant before the court, then the amount which is deposited by market participant with the MI, out of that amount, the MII can release up to 5 lakh rupees to the investor as an interim payment. Now this interim payment can be paid only when the investor provides an undertaking, an indemnity or a security to the MII that he will return this money in case the challenge which is filed by the market participant before the court is decided against the investor. In such a situation, the market participant is required to receive back the entire deposit amount or the other amounts which are mentioned in the court order. So, in such situations, the investor would be required to refund that amount. Likewise, in case the matter is decided in favor of the investor, then in such case, the MII will release the balance deposit amount to the investor, uh, and the investor will receive the entire compensatory amount as per the court order. Now, if the challenge is again decided by the investor client, then the matter is again going to court of the appellate tribunal. Then investors should always ensure that it returns the amount. In case the investor does not return this amount, then the investor shall not be allowed to trade in the securities market. So there could be further consequences which says that the demat account or the mutual fund holdings of the investor shall be frozen, or its trading account will be also frozen, so that the investor cannot trade in the market. The MII is also, as who is the super to whom this matter is allocated, will also monitor that the market participant is complying with the terms of the arbitration award or the judgment passed by the court where the matter has been referred or challenged before that court. So this entire mechanism is there to ensure that when an arbitration award or the court order is passed, it is properly implemented by the market participant or the investor against it. So in whose favor the award is or the court order is received, they should receive their compensatory part, and against whom they should be required to honor those awards and court orders. Now, the proceedings. Now, how the conciliation arbitration proceedings are done. As I mentioned earlier, the ODR institution who is handling this matter or the for conciliation arbitrations, they will do the online mode only. The online mode is in such a manner that they will the both the parties, that is the investor and the market, will have to come on a video conference and participate by using their logins and passwords which are already provided, and the proceedings will be conducted through the portal of the ODR institution. In case the investor or client does not have themselves have the online facilities like through normal computers or other kinds of equipments for participating online, then they can definitely visit the investor service centers of the MIIs which are available across the country and use their facilities to participate in the conciliation and arbitration proceedings. So you may visit this list. This list of investor service centers are available on the websites of the exchanges and depositories where you can go, and mostly it covers the most of the cities of the country. Now, the venue and seat of online arbitrations. So, from a legal perspective or the online perspective, this is a very important requirement that the place and the seat of conducting of this proceeding is determined, because since everything is online and people are participating from different locations, and it is decided that the dispute where the dispute is between the investor and the market participant, the investor where he is residing would be considered as the venue and the seat of the proceedings, especially for the arbitration matters, where the client or the investor is not an individual or like a company or other firm types of organization. Then the registered place of business in India would be considered as the place and the venue of arbitration or the proceedings. Now, this venue and location will be based on the KYC documents which are available for the trading account or demat accounts or other ways of submitted with the market MII or with the as per the details available. In case there is a dispute between like a institutional and corporate clients and the market participant, then the market participant has its registered office business in India could be considered as the place uh, where the location and venue of arbitration is concerned as per the relevant case of documents. So it is the circular of RSAB is very clear in terms of ensuring that the venue and seat of arbitration is properly defined and determined so that there is no subjectivity or ambiguity around it. And it is also important from arriving at the which court, that based on the venue and seat is determined, the court against where the arbitration award can be challenged depends on this location. So if the venue and seat of arbitration is in Mumbai, then the relevant courts will be the Mumbai courts where the challenge can be made.